They call you, as the opposing side, as the first witness, and they try to get under your skin. And they're going to ask you yes or no questions that frame you in a bad light. Remember and trust the process, which is if they've asked an unfair question and they won't let you respond or answer, remember, that's my job.
Yeah.
I've just caught that. I'm going to come back and I'm going to ask you that question. Being combative with opposing counsel or the other party or asking questions back, do not ever ask a question back in court.
What is going on, everyone? My name is Mark Reel Jr., the Father's Rights Attorney, and you are watching another episode of the Father's Rights Playbook. On today's episode, we have part 5 of a 6-part series covering everything domestic violence in the state of California. Joining me once again is partner here at Real Father's Rights, Ryan Dreyer. Ryan, how are we doing today?
Doing great, Mark. Thank you for having me.
Awesome. And on today's episode, we are going to talk about what it takes to be a good witness in your own domestic violence restraining order defense. So I'll go ahead and I'll set the table here in regards to kind of what we'll cover over the next few minutes. So we go in, and when you're defending the restraining order, the opposing party is going to put their case on first. They're going to put their witnesses on first. So usually the opposing party, maybe a witness or two, come on and testify to what they saw, heard, what happened, and they rest. Once they rest, it is our turn in defending the restraining order. A lot of times in these cases, it's just the parties who testify. We've already covered in this series that it's really a credibility contest and how important it is to be believable. So as you're prepping a guy to take the stand, what are some things you're helping them with, teaching them, showing them how to do to be an effective witness?
All right. So first off, nonverbals rule, right? Because that's one of the areas that a lot of people don't control. They allow themselves to get angry. They shake their head. They mutter under their breath, anything. Let's start from the beginning. Your job as a credible witness or as a good witness starts the moment you're in the hallway, right? And the moment the deputy first sees you. And walking into court, being polite to the court staff, being nice, smiling, not glaring, never with your arms crossed, right? All of these small ones, the judge is going to notice that. The other thing too is the deputy's going to notice, the clerk's going to notice. They talk to the judge, right? And it would be foolish for you to think that if you're rude to the deputy, you're rude to the clerk or someone else, that's not going to get back to the judge. That's number one. Number two is when you go up, I need you to be a banker in church on a Sunday in front of God, right? So I need you to not have your arms crossed, not shake your head, not mutter under your breath, not glare, not try to interrupt, right? Allow the process to take its path.
Be calm, cool, and collected.
Calm, cool, and collective.
Sit back, be in a relaxed position, looking at your attorney. That's the safest place to look in the courtroom, is to look at your attorney.
Yeah. No laughing when they say something. None of those things, right? And again, the judge is looking at your demeanor even before you've testified. While those other witnesses are going forward, they're watching you.
It's a really good point, because when we're defending a restraining order, there are going to be other witnesses on the stand prior to you. I always instruct my clients, there is zero reaction. You sit back, you can have your computer out maybe you just have a notepad, you can be doing those things, but you shouldn't be shaking your head or glaring or sighing or aggressively grabbing your attorney and pointing at anything. I promise you, doing that's not getting you anywhere. It's not a good look.
It is not. Now when we get up to the stand, when they ask you a question, I want you to stop, do 2 Mississippis. Breathe and then respond. It is not a race to get it out. We're not raising our voice. We're not getting agitated. We're keeping things as calm as possible. Now, can you show emotion? Yeah. Hey, this was hard. And the attorney can lean in that with you. Hey, do you need a second? This is tough, right? True emotion is fine as long as it's not anger.
Yeah. And if you can't control the anger, you better be acting like the most boring librarian that you've ever seen up there on the stand.
Right.
Put the judge to sleep. That's better than being angry.
Remember this. The judge looks at it as, if you can't control yourself in a courtroom, then you couldn't control yourself at the time of the incident, right?
Yeah.
And so that's where, now the next one is, answer the freaking question and nothing else but that question. If it's a yes or no question, answer yes or no. Now you can say, may I elaborate? The other attorney's going to usually say, no, thank you, right? But this is how we have to understand the process of court. If a question is asked on direct testimony, say by the other side, I, as your attorney, am allowed to cross-examine or answer the question, right? I can, because this is one that they've been doing lately, a lot of attorneys, they call you, as the opposing side, as the first witness, and they try to get under your skin. And they're going to ask you yes or no questions that frame you in a bad light. Remember and trust the process, which is, if they've asked an unfair question and they won't let you respond or answer, remember, that's my job.
Yeah.
I've just caught that. I'm going to come back and I'm going to ask you that question. Being combative with opposing counsel or the other party, or asking questions back, do not ever ask a question back in court to the attorney.
My thing is to, especially when you get called as the other party's first witness, is you do answer it in yes or no. And you'll find a lot of attorneys aren't skilled enough to actually get the information out of you. The number of times that I've had a client called, opposing counsel dances around for 25 minutes trying to get an answer because they want to try to get it in yes or no format and can't do it, is amazing. Usually the biggest mistake in those situations is elaborating, is giving a decent attorney a little bit more thread to pull on. If they ask you a really bad question, not bad in context, but if they just ask you a bad yes or no question that's a dead end, you answer yes or no, we're all standing there like, or sitting there like, oh, well, where are we going next? So allow them to do that. Don't try to be your own hero on the stand.
No, answer the freaking question. Don't give a narrative, right? Mm-hmm. We come into court and we have all this stuff that we want to get out of our head, right? And that you want to say. And this is the other thing. I need you present when you're in the courtroom. I don't want you thinking as they're asking you a question, this is what I'm going to say. You have to be present. You have to be answering that question and only that question. Again, no volunteering information. Please, please, please. You have to just follow the rules. No argument with opposing counsel. Answer the question that is posed to you. Remain calm. Take your time. Remember, speak slowly. We generally, hopefully, in some counties maybe not, there's a court reporter. Yeah. But remember also, when we do have a court reporter, everything that you say is going to be down there. Now, it's not going to catch your tone or anything else like that. But the judge, trust me, is clocking your tone. Trust me, the judge is looking at your nonverbals. That's part of their training, is to look at these kind of things. Keep it together and follow the game plan that your attorney has set forth before you. Know that the attorney is going to ask you these important questions. That's why you guys have met. That's why you guys have gotten together. Don't try to win your case solely through your own testimony, right? I think that's very important. Yeah. Allow the process, allow your attorney to score points, especially in the defense, right? A lot of times, all we're trying to do is sweep out specific elements, right? If there's a bad fact against you and you and your attorney have talked about it, don't try to get around it.